Hi folks, and welcome back to Contract A. This is the third and final, I promise, video in our series on intention to create legal relations. We are at week 2 of our unit, and we've had a little look at some theory and how it ties into intention to create legal relations. We've had a look at homogeneous, and now I want to have a little look at the what I call the old stuff. Let's jump into our Prezi and have a look at the old stuff. Now, why do we need to look at the way that courts used to go about doing things in terms of presumptions? Well, I've already touched on one point where the old arrangement was quite useful, and that is you've got neatly grouped cases according to the different types of relationship that used to be categorised. That can provide a fruitful starting point for you to examine a line of cases which may apply to your particular set of facts. Another reason is because despite the way that I've kind of pitched homogeneous to you in video 2 and the general consensus, which is homogeneous has basically swept away the old process of applying presumptions, there is in fact a modicum of doubt as to whether that is what homogeneous did. So I want to take you to the point in the case where we find this paragraph that gives rise to some ambiguity that keeps some authors and courts still clinging on to the old way of doing things. Let's have a look. So the first thing that causes a bit of ambiguity is the phrase "this context." And the ambiguity arises because they could be talking about this context as in being the broader context of the whole area of intention to create legal relations, or they could be talking about this particular factual context being arrangements between a body and a minister of religion. Okay, that's the ambiguity that we're talking about. So first up, they start by saying in this context of intention to create legal relations, there is often reference to presumptions. It is said that it may be presumed that there are some family arrangements which aren't intended to give rise to legal obligations, and it was said in this case that it shouldn't be presumed that there would be intent between a body and its engagement of a minister of religion. For our part, we doubt the utility of the language of presumptions in this context. That's where your ambiguity creeps in. By this context, do they mean what they've just finished saying? In this case, regarding matters of engagement of a minister of religion? Or do they mean by this context the whole area of intention to create legal relations? And I would maintain, also Wilmot maintains, Grohr maintains, and it seems to be the consensus of courts, that by putting together the strongest area where presumptions have traditionally been the case, which is family arrangements, and this particular case all into the one sentence, what they're saying is, in this context of the area of intent to create legal relations, you've had some presumptions, family, matters of religion, where it's not the case, there's no intent. Then they go on, for our part, we doubt the utility of using the language of presumptions in this context. That is, in the context of the area of intention to create legal relations. So that is the crack of ambiguity. Wilmot doesn't really talk about it. Grohr does talk about it, however. And I quite like what Grohr has to say. They quote the paragraph that we've just discussed. And then he says, whether this means that the old presumptions no longer have any place in determining the question of parties' intention is not entirely clear. And then they go through some of the cases. Some cases have rejected the use of presumptions as a basis for ascertaining intention. Other cases have been more reluctant, and some GRAW notes just actually ignore homogeneous and go on continuing to apply the presumptions. However, GRAW concludes the upshot is that most cases now don't refer to presumptions at all and simply refer to and apply the objective test instead, answering the question as to whether the parties truly intended their agreement to be contractual by looking at what they said, what they did, and the circumstances of how they reached their agreement. So the real question now is simply the question of proof. Okay, so I just wanted to flag that for you. You're going to have to be masters of language. Now I am the master. As lawyers. And you're going to have to get used to fairly finely dissecting judicial decisions like this and working out, okay, what do I know about language? What does this particular piece of language suggest to me? How do I interpret it? How have others interpreted it? So it might seem like a fine-grained process, and it is, but it's something that you're going to need to develop your skills in as you move along in your degree. So that's the little bit of ambiguity in homogeneous. As GRAW says, the case law tends to come down on the side of, and I agree, it just makes sense when you actually read that paragraph in its entirety a couple of times, that they have actually done away with presumptions, full stop. But looking more at the interesting issue of presumptions, I kind of thought that perhaps you hadn't come across the idea of a presumption before. There is some explanation of it in your study guide. I just wanted to take you through perhaps a little bit further exploration of that point. So if you haven't heard of presumptions previously, and when you do evidence, you'll find out there's presumptions of law, there's presumptions of fact, there's rebuttable presumptions, there's irrebuttable presumptions, there's a whole lot of different presumptions that you will encounter. And how would you go about finding this out if you don't, for example, have a handy little legal dictionary there with you? You can zip across to the library website and you can go to the database page. And if you click on the database page and you go to the L database, click on Lexis Advanced Pacific. And here's something I prepared earlier. Lexis Advanced Pacific is great for legal research. I'm sure you will have already encountered it. If you haven't, here it is. This is the little beastie. And what I simply did was I typed in there rebuttable presumptions, selected cross on evidence, and you just add that into your search filter, and bingo, you come up with whatever evidence, because rebuttable presumptions are part of the rules of evidence. Because what a presumption does is, as you worked out from homogeneous, it says who has the burden of proof, who has the onus of showing that a particular point is either the case or not the case on the balance of probabilities. Okay, so here you go to cross on evidence and you have a look at presumptions. And here's something I prepared earlier. Okay, so here we are at section 4 of cross, and he's talking about presumptions. Using your lawyerly skill of selective reading, you would flip down past the introduction. You see a big heading there, main senses of presumption. That's the information you want to know about. That's the information you flip down to. There are two main senses in which the word presumption is used by lawyers. Firstly, a presumption sometimes means nothing more than the conclusion that has to be drawn until the contrary is proved. You're innocent until you're proven guilty. Okay, fairly fundamental presumption there that applies in law. Secondly, and more frequently, it denotes a conclusion that a fact exists which may or must be drawn if some other fact is proved or admitted. So if you've got fact A being the case, then we're going to presume fact B. And they give the example down further of undue influence. And you'll talk about undue influence when you do contract B later on in your degree studies of contract. But in that situation, what you're looking at is a kind of relationship. What kind of relationship do the parties have? Is it a family relationship? Is it parent-child? Classic situation there. Is it solicitor and client? Is it doctor and patient? Is it minister of religion and devotee? So in that area of undue influence, they also categorize relationships. And what they do is they say, if those relationships apply, then we're going to presume that any contract that results in that scenario is going to be as a result of undue influence. Much like here, where on the old way of doing things, the courts would fossick around, try and find categories of relationship, and they would say if the contract arose in that kind of relationship, we're going to presume that there either was, for example, in commercial relationships, or wasn't, for example, in family arrangements, an intention to create legal relations. Okay? It's a kind of bifurcated process where you look at and classify the relationship, and then you presume something like intention to create legal relations or undue influence. Okay, that's the way presumptions work. And then all it does is it gives the burden of proof to the party that is seeking to prove to the contrary of whatever the presumption would have us believe be the case. But as the High Court said in homogeneous, really, in cases where intention to create legal relations is at issue, the party that's seeking to rely on the contract is going to have to prove their case anyway. So presumptions don't really get us any further down the track. So it seems like they've been swept away following homogeneous, but in undue influence that you'll talk about next term, it's still that whole system of or process of working out a conclusion on undue influence. It all still exists. So that is the sense that we use presumption in. I hope it adds just a little bit more to your understanding about why we use presumptions. And the last thing I wanted to talk with you about today was just a brief wrap up of the chapter. And as you can tell by the time, it's going to be a cook's tour. I don't see a whole lot of point in these videos in me going through blow by blow what happened in the chapter, because you've already got the study guide for that as a kind of a general bird's eye view of what the text does, and then you've got the text itself, and then you guys are going to be reading the casebook as well. So there's no point rehashing all of that material. The point of these videos really is to provide you with some extra stuff, which is why we've gone through homogeneous in a fair amount of detail, and we've also had a look at the theory. But it's just to point out, I guess, bits and pieces from the text that might not otherwise flag your interest. Obviously, the areas of relationship that used to attract the presumptions are husband and wife, family, business and government, and different presumptions tended to apply to each. Obviously, where business is concerned, the presumption was that it was going to be there was going to be intention to create legal relations because of that commercial context. Husband and wife and family, the opposite is the case. So no intended legal relations there because of the informal and familial kind of context of the goings on there. What I will flag for you is in terms of government activities, you will note that the decision in Coogee might not make a whole lot of sense to you. I'm looking at page 130 of Wilmot. So a plaintiff entered a contract to sell its motel to the Commonwealth. They got a letter from the department saying that approval had been given and funds authorised, and that the transaction would be settled in July. A letter of intent was sent by the Parliament head to the director, and in an action for specific performance, the court held the parties had not formed the requisite legal intent to contract. And it seems like from the factual matrix there was fairly clear intent. Part of the reason for this is that courts are fairly reluctant to trap a government into contractual relations at the best of times, and principally this is to allow the government some flexibility in terms of its dealings where there might be a policy change or a governmental change. There has to be very, very clear intentions to create legal relations there, generally speaking. I'm just making a generalisation here. And you'll see it come out even more strongly when the purported contract relates to a policy initiative. The government can't really afford to be fettered too much in terms of the decisions that it makes in furtherance of policy. They have to be flexible enough to be able to change their policy initiatives as the social conditions dictate, or I guess as the flimsy will of the politicians dictates, depending on how jaded and sceptical you are. So usually courts will allow the government a fair amount of leeway on those matters. So that's just to clear up something in case you were thinking, Coogee seems a bit of a weird decision to have come down on the side of no intent to create legal relations. The other thing that I wanted to talk with you about very briefly was the issue of honour clauses. And that is the really express way of saying, hang on a second, this whole agreement is not intended to be legally binding, and here's our evidence that our intent indicates this, and then you just pop in a clause into your contract saying this agreement's binding in honour only and is not intended to be enforceable in any court of law, blah, blah, blah. So at the very beginning of the video, I said usually matters of intent and intention to create legal relations are implied. Sometimes, particularly where you want to make it super clear that it's not going to be justiciable, you do put a clause into your contract saying and evidencing for all the world to see that neither party intends this to be a justiciable contract. Finally, I just wanted to flag for you at the end of the chapter there that you get to re-engage with the Carlisle case where they talked about intentions of to create legal relations and the issue of puff and puffery. And gotta love that case. It's useful for a number of different things. Thanks to the student that put up the video, the little parody video of Carlisle. That was great. And that is intention to create legal relations. So if you have any queries, if you have any questions, please contact me, phone, email, post up a message on Facebook. Other than that, I look forward to discussing things with you in the Zoom, and it's bye for now.